At the lunch break, the very early lunch break, on day 3 of Florida versus Sarah Boone, the state has rested their case. The defendants made their judgment of acquittal motion. It was promptly denied by the court, and we're waiting for Sarah Boone to testify. The court did the entire colloquy with Sarah Boone, and then the defense was like, wait. We need more time. So multiple times after the state rested their case, the defense was like, wait, can we have 10 minutes? Sarah Boone needs to go to the bathroom. Wait, can we have 10 minutes to address this with the court? Wait. We need another amount of time for Sarah Boone to examine the physical evidence and look at the suitcase. And we need to do that with her. We need to prep her for her testimony. But that was after they said, we need to talk to her about the colloquy with the judge. So it was, she needs to go to the bathroom. We need to talk about the colloquy. We need to do this. And then the court was like, I am not going to put her on the stand for 20 minutes, go to lunch, and then come back. I wonder if, because the defense did say there would be a bit of a break in the witnesses, they don't have any other witnesses for today. So I think Sarah Boone, they anticipate taking the rest of the day to testify. We'll see if she's done by the end of the day at 5 p.m. So they're going to be running another 5 hours of court with Sarah Boone. Will her testimony be done in 5 hours? I don't know. Maybe it will, maybe it won't. But she's going to have an opportunity to look at the suitcase before lunch is over and meet with her lawyers before her testimony. And then maybe she'll finally be on the stand. So for an entire morning of court, there was maybe 20 minutes of a cross-examination that didn't have much direction or point. And that's where we're at.
The court has the opportunity to review the case law, review the arguments provided by both the state.
Remember, these arguments have been made multiple times before this court. He's reviewed this case law multiple times. This is not a novel question to him, and he knew what she was going to say because we've seen it before.
And the defense court finds that a overt act has been established. Case law is clear that a scintilla of the providing of an overt act is sufficient to provide the self-defense jury instruction. An overt act is not something that's specifically defined in Florida case law. It's something that's from the totality of the circumstances, seemingly under the authorities that the court has reviewed. As such, the court is going to find that under Holland, a overt act has been established and will allow the defense to proceed with evidence of reputation and specific instances of conduct and
he's not looking at the attorney's
evidence so long as the necessary predicates are established for those
It is a low bar.
Any questions or clarifications with regard to the court's order?
That is a big win for the defense in this case.
Defense.
I think it would help if we went through my exhibits involving the blow-up photographs and these other photographs, because I think
the bar is low. A scintilla of evidence.
I don't know if you want
the barest
to
amount.
deal with all of them one at a time in front of the jury, or whether we want to just talk about them.
I'm surprised.
So that we
Yes, it's better for appeal.
Are there any objections to those items?
So the defense will present their defense.
Shown a lot of different things, including like a rap sheet.
And if it is, well, it will absolutely protect it on appeal. We are at the lunch break on day 3. Sarah Boone is still on the stand. She took the stand after lunch and the court allowed in her defense. It was a very big win for the defense, and it's going to extend this case a little bit because we're going to have more experts and more witnesses coming in for the defense with regard to the self-defense and the battered spouse claim that we weren't sure would be allowed in. The court found that there was a scintilla, which is like the littlest of little bit of evidence that there was an overt act. The court did not say which overt act there was, but Sarah Boone testified in direct that he was saying that he would fucking end her from the suitcase, and that is what she heard, and that is what she acted on. I'm sure when the prosecution gets up, they are going to ask if she's ever said that to anyone before in all of the statements she's given, because it seems that perhaps she has not said that in any of the conversations she has had about this case, including with her domestic violence experts. With that, the prosecution will be cross-examining her probably later today into tomorrow, and then we will get into the defense medical experts with regard to battered spouse and the self-defense claim here. then the prosecution will be able to bring rebuttal witnesses when the defense rests their case. So yes, this case is going to go on a few more days than it would have had the court kept that defense out. The jury will get to decide ultimately what the facts of this case are and whether what she says in court now holds more water or whether what she said in her interviews with law enforcement saying things have been better, things have been good, and we were just messing around. It was a good day and we were playing around. And at the end of the day, was this a second-degree murder where she knew he was begging to be released, zipped him in and said, I'm going to bed, get out, good luck getting out? The jury will also be allowed to consider the lesser included of a manslaughter, which really goes to negligence. Was she negligent in leaving him there? Was she not doing it with a depraved heart, but was she just like, meh, I'm going to bed? If that video didn't exist, this might have been charged, if charged, as just a manslaughter, where she said, this was an accident. I just went up to bed. I was drunk. I zipped him in. I totally forgot. That was on me. This might have just been charged as a manslaughter, but the video of her mocking him is why the prosecution, I think, brought the depraved heart here. We are moving on to cross-examination.
George knows somebody named Crystal. You ever mention Crystal in your text messages about being one of his bitches?
That's coming in hot.
I don't remember.
How about Christine? Did George know a Christine?
He's trying to piss her off first.
How about a Pamela Erickson?
These may have been people that he was communicating with on whatever the platform was.
On your phone?
I believe so, yes.
And did you find these communications?
I believe I found one or two of them.
Is he going with she contemporaneously found out that he was chatting with folks on her phone close in time to this night? And that's why she was pissed? Oh, I have questions. Like, he is coming in so fucking hot with this. I'm going to back up. He's like, we're not going to fuck around. Who's Crystal? Who are these women? Oh, I'm going to need some timing.
Did you ever mention Crystal in your text messages about being one of his bitches?
I don't know. I don't remember.
How about Christine? Did George know a Christine?
Leave Christine out of it.
I don't know.
How about a Pamela Erickson?
These may have been people that he was communicating with on whatever the platform was.
On your phone?
I believe so, yes.
And did you find these communications?
I believe I found one or two of them from some of them.
And did you send a long letter to his family to relay to him about George and his girls that he was cheating
What?
with?
I believe so.
Okay, so you do know those names, right?
I don't remember them. It's been however long.
Okay.
At the end of day 3 of evidence in the state versus Sarah Boone is done with her testimony. Very much to my surprise, the court granted the defense motion for the self-defense. So we are going to see expert testimony, and it looks like this trial may be done with evidence by Friday. So stay tuned, because Friday might be closing arguments. But I was very surprised at how short the cross-examination of Sarah Boone was. Is this the prosecutor getting frustrated and just being like, I'm done with you now? Is this the strategy to not give her an opportunity to answer and just point out all of her inconsistencies in argument and just be like, you're going to say what you're going to say. We'll just point out all the differences. I don't know. And we're not going to see until the end. But it felt like somewhere in the middle, they're like, okay, so let me get the timeline straight. You remember this. You don't remember this. It seems very much to me that Sarah Boone does not remember this evening at all, that there was quite a substantial amount of alcohol involved, and that she really doesn't remember and is trying to fill in the gaps based on what was on her phone and what benefits her defense, but that she truly, I think, does not remember that evening. And she kept playing word games with the prosecution, but they could have gone inconsistency by inconsistency. They did not do that. At one point, though, they did pull the suitcase into the well and have Sarah Boone come down into the well to show how much opening she left on the suitcase. If that's contradicted in the video, they're going to point that out during closing and probably leave it for closing. They did not talk about any abuse towards the victim from the defendant in the cross-examination of her, which I found to be surprising. And maybe they will bring in the officers to just testify about what happened, and they're going to use those officers in their rebuttal case and say, yes, we came out this day and this is what we saw between the defendant and the victim, and not give her an opportunity to respond. But I don't know. So we will see what happens in their rebuttal case. I imagine the defense is walking away from court today feeling like this was a huge win. It's really going to boil down to how the jury reads Sarah Boone's demeanor. You could see her demeanor switch at different times on the stand between the topics she was talking about. And then it got very hard to understand words on cross. And she was just the word games, like in the interview with detectives, came out. And how much weight the jury will put on her testimony versus how much weight they put on her police interviews is going to depend on them and the rest of this case. The defense has multiple experts. The prosecution has rebuttal experts. And we will see what all comes in at the end of this case. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.